All right, students, welcome to BUL3130's lecture for Chapter 42, Employment Law. So this is a new section for this semester, and we want to kind of spend some time with it. I added this in due to the fact that it is important, especially for a business owner, to have a good grasp of what business law is and how it can cause issues to arise within a business, especially when you're getting going and you're trying to hire in staff, you're trying to get your business set up. It's good to know what your rights are as an employer and what the rights of your employees are. And then for those who may not be in a management setting, knowing that what your rights are as an employee is also very important. It's one of the things that you probably need to know those rights as much as you know your basic constitutional rights. So it's important to have a grasp of that, no matter if you're running things or you're the one who is doing what is instructed by those employers. All right, so we'll look at labor law, employment discrimination law, and then employee protection throughout this. We'll also look at some of the defenses, of course, as we always do, for different types of allegations or charges that may be applied. We'll even look over how, over a stretch of time, those charges change and how they kind of move up and down. And some of that you'll see how it correlates to where there were some type of economic issues going on within our nation. So when the economy is maybe not doing quite so good, there tends to be a little bit more of an issue with labor law. So labor law in and of itself is designed to make sure that the management and the employees know their rights, know how things are set up. Plus, it also gives the employees the ability to negotiate with management on the terms of their employment and how that works. So labor law is a little bit different than employment law. We're studying employment law as a whole, labor law being a part of that. Prior to there being labor laws, you did not have the ability to negotiate in the way that was built after that. Now, it wasn't, and here are the labor laws, and now we're going to be able to negotiate. Everything's going to be good. No, there were subsequent acts that build upon that. So the first act of 1932, the Norris-LaGuardia Act, started things off, but there was still reform that had to be done as it went along. So Norris-LaGuardia established U.S. policy of full freedom of labor to form labor unions without their employer interference, and it withdrew from the federal courts the power to issue injunctions in nonviolent labor disputes. Any controversy concerning terms or conditions of employment or union representation. So prior to this, the federal government would get involved and basically force employees back to work, no matter what the circumstances were. It didn't matter if they were violent disputes going on or nonviolent disputes. They would just intervene and say, okay, you're going back to work. After Norris-LaGuardia, labor was given the ability to form these unions and be able to exercise their rights to try to get management to pay attention and work with them on better. And most time people think about pay with this. It's not so much about the pay. It's not so much about what they're earning. It is a lot of times, and especially in the early days of labor law, it was about working conditions just as much as it was about what they were making and what kind of pay they were getting. Through the years, other benefits have become active due to labor law and the ability to negotiate and work uh, with management to try to get employees or labor a better package, the ability to have health insurance. Uh, in a lot of cases, that was a negotiated part of a not so much a labor dispute, but the basic negotiations that labor and management go into. Now, if you're in a job that has a union and you're part of the union, and in some cases, even if you're not, because a union represents the whole collective, not just those who are a member of that union, uh, things will be renegotiated every few years. So the contract will work for a certain amount of time. Uh, just in recent years, when we had the strikes with Screen Actors Guild, we had the ones with the Writers Guild in Hollywood. We had strikes with the major car companies here in the U.S. It was the United Auto Workers Union striking against Ford, GM, and Stellantis. Those were union disputes that they'd initially went to negotiation and could not come to an agreement. So it turned into an issue where labor went on strike, and they uh, exercised their right to do so in a peaceful manner. Eventually, solutions were made, and a lot of what labor asked for was given to them. There was a few concessions that labor had to make in that. But that's part of that negotiation is, and sometimes negotiation, a tactic in that negotiation is putting the workers on strike. Now, UAW did so in a floating basis. So they would strike at one plant for a certain amount of time, then strike at another, and they set it up on a revolving basis so that they were not, they didn't completely cripple one company by everyone who worked for that company walking off at one time. They did so in a way so they got their message across, but it didn't look like they were just trying to use a bully pulpit, if you will, to get what they wanted. They were, working at it in ways, and the strikes went on for a while, but eventually it was negotiated to the point where both sides could eat what they had to eat as far as the pain of it, and then come to an agreement. Most of the time in these type of things where unions are formed and you get a chance to negotiate and bargain, it is called bargain. A bargaining unit is normally what a union is. It's the bargaining unit of a workforce. That normally when those are in process, there's not someone who comes out with a full win. There's normally going to be some concessions that both sides have to make. That's the reason both sides will, throw numbers in there that they know the other side's not really going to accept, and so they kind of try to work to them. UAW threw out big numbers to begin with and stuck with it for the majority of the time that their members were striking, and eventually began to back down on those as each one of the companies began to negotiate with them in the right way, in good faith. That the negotiation between labor and management is supposed to be a good faith negotiation. In other words, both parties come to the table with the hope of a resolution, not coming just to, push without anything happening. The National Labor Relations Act of 1935 declared a federally protected right for employees to unionize and to bargain collectively. It prohibited unfair employer practices. That identifies five unfair employer practices, which we'll talk about here in a little bit. And it prohibited it created the National Labor Relations Board, the NLRB. That board is the one that will hear cases or complaints about labor not being treated in the way that it should. They'll be the one that will hear if there is a complaint about someone not being allowed to unionize, or a company who is putting down on employees because they want to form a union. A Within the last 5 years, some of the employees of Starbucks began to form unions in different areas, and there was a big thing between the Labor Relations Board and Starbucks, where Starbucks was being accused of hindering the process and the ability and the right of those employees to form a union. This also happened to a small extent with a couple of Trader Joe's stores that had employee unions formed in it. A couple of those stuck. One of those, at least that I know of, was voted down. The employees actually voted it down, but it was prior to the vote where these companies were trying to intervene and keep that vote from happening. So part of how the labor union set up is the employees would come together and have a vote, and it takes a certain amount of employees to get that approved and for them to form a union. And it didn't happen in at least one of those Trader Joe stores, but it did in a couple of the others. And some of the Starbucks stores it did. Amazon had some recent unions formed within their distribution centers or their warehouses. So it's labor unions still get formed, but we don't hear about it quite as much as it would have been, almost 100 years ago. So we're at the 90-year point for when the National Labor Relations Act was instituted. So 90 years ago, that became the law of the land as far as labor law went. And so we're 90 years out, and we still have disagreements and things that happen between labor and management, plus the Labor Relations Board being brought into it. So there's still a lot that goes on. So part of what the Labor Management Relations Act, this one was a little bit further after. This one would have been formed, I believe, in the 40s. So the Labor Management Relations Act came about in 1947. So it was a little bit later. It was also called the Taft-Hartley Act. So that may be a way that you've heard of it before. In some classes, you do cover that as far as business classes go. And really and truly what it did was prohibit unfair union practices. So we had the Labor Relations Act that prohibited unfair employer practices. But then, Congress realized that there were some unions that were doing stuff they shouldn't do. And so the Labor Management Relations Act instituted some unfair practices that unions had been involved in, and they wanted those stopped. So it prohibited those. It also prohibited what's called a closed shop, the agreement that mandate that employers can hire only union members. There are places where that does happen, depending upon the state. There are some jobs that will be labor only or union only, and those but it does allow union shops. So employer can hire non-union members, but then require the employee to join a union. So it seems kind of counteractive there. It prohibits closed shops, which are agreements that mandate that employers can hire only union members, but it allows a union shop. So what it does, it gives the employer the chance to hire someone who may not be a member of the union yet, maybe someone who's a recent graduate just getting into the field, whatever it may be, but it can require them as a continued part of their employment to join the union that works, whether it's pipe fitters or whatever it may be. Some of the bigger union shops are normally in the construction industry, where and not so much construction of just the house building, but electricians, plumbers, those type of things, that they're very union heavy in a lot of areas. So that's one of the things that you look at. Labor Management Reporting Disclosure Act aimed at eliminating Labor unions. This one happened a little bit further back. That one is the Landrum-Griffin Act, is what it was known as. That one took place a few years later. So those were the labor law issues that were looked at, and how labor and management began to be able to negotiate and get to the point to where we then started bringing in employment law that dealt with issues outside of just the negotiation part of it. Some of the unfair practices that we look at and we see with this, as far as employers go, you notice that some of these kind of they match up, and they just maybe change as far as the way they're described so that it fits in with which side of this they're on. One of those that's big, I stated earlier that their bargaining has to be in good faith. So when they come to the table to negotiate, they have to do so in good faith. Refusing to bargain in good faith is a violation of labor practices, and the union could lose their ability to be a union. The employers could be fined, and these are not small fines. And the National Labor Relations Board does not play around when they start finding these employers who do not want to negotiate in good faith. So it's a danger to them to not do this. So they need to do this. Good faith, of course, is one of those things that's up to interpretation. There's not a law written anywhere that says exactly what good faith bargaining is. It just means you're coming and you're willing to work toward a resolution. So you could, prove someone's not negotiating good faith if they never once want to come to the table. They never once want to hear the other side. They do not make any other offers or counter offers when they're on the table. So that good faith is, exactly what it sounds like. You're coming in and you're going to negotiate. All right. You're going to bargain. Bargaining means we go back and forth. We work on where, the parties can be the happiest, even though they're not going to get everything they want. So they, do that. Discriminating against union members is another way that employers can have an unfair practice. Interfering with that right to unionize. That would be probably one of the more common that we see now, as far as companies trying to keep employees from doing it. Companies can try to dissuade their employees from joining a union, but they can't outright tell them no, they cannot. All right. So interfering is an outright, we're blocking it, we're keeping you from doing it. You can't do this, you'll be fired if you do it. Something along those lines. Dissuading could be that, we offer a competitive rate to what union jobs do. You're basically telling them you don't need a union because we're competitive with what the union jobs are. That's not interfering with the right. You're still giving them the right. If they want to, they can. You're just giving them an option. Discriminating against them would be giving better positions to non-union members, maybe better pay to non-union members, those type of things. Dominating union and discriminating against any employee is an unfair labor practice or employer practice. The unfair labor practice or union practice is coercing an employee to join a union, especially in the earlier days of unions, and now even 90 years out from this all beginning, there's still cases where a fully unionized job force will try to coerce anyone who joins that job force into joining the union by force, by threat, by a lot of different means. Refusing to bargain in good faith, once again, that union has to come to the table the same way that the employer does. They have to come in there and decide that we're really going to negotiate. We're not just going to throw numbers out there and be a bully and try to control everything. We're going to negotiate. Cause an employer to discriminate against non-union employees, threatening a employer or threatening a company that they will picket or cause some type of disruption in business if they do not force these employees to join In other words, trying to get the employer to coerce people to join the union or fight against them, feather bedding. And this one, I want to kind of let me find it again where it was at here, so you get an idea of what it is. So I can't fall right on the definition, but it is basically when a union will try to force a company to create jobs just to increase the number of union members in a job or in a company. They'll try to get them to, bolster it and do things on those lines that are maybe not the best. And it ends up being that those employees are not actually doing anything, but they're forcing the employers to pay for work that's not performed. In other words, showing that there's more to be paid for there than what actually is being done. If a job says we do X, Y, and Z, they want us to pay for, T, U, V, and W prior to X, Y, and Z. That would be feather bedding. Bringing in people who are not actually doing it, showing stuff on the books that's not there, whatever it may be. Feather bedding is one of the unfair labor practices. Picketing an employer to require recognition of an uncertified union. A union has to be certified. There has to be a vote by the employees, by the actual employees that the union wishes to represent. That vote has to be ratified through them and submitted to the National Labor Relations Board for it to be a certified union. So for a union to be considered a true bargaining unit, they have to go through the steps of being recognized. If they're not recognized, then they cannot picket legally. They cannot force or try to get a company to come to the table to bargain because they do not have any, there's not any teeth in what they're doing. They need that backing of the NLRB to make sure that they can do what they need to do in the union setting. Engaging in a secondary activity. Secondary activities are when they go after a company who does business with a company that they are picketing or striking against, and they threaten them or try to get them to cut off supplies. They could threaten, if they're picketing a trucking company, they could threaten the suppliers for that trucking company or the buyers from that trucking company, other companies that use their services. They could threaten them with a strike if they do not cease activity with the trucking company. In other words, trying to hurt them and hit them in the wallet and get them to come to the table and negotiate. That is one of the things that will get a union in trouble very quick, and it is fairly common practice that they do that doesn't get seen quite as much. And then, of course, their dues have to be dues that are not excessive, and they do not discriminate against anyone in the way that they levy those. All right, so that was labor law. Labor law is prior to the 1964 Civil Rights Act, the Equal Pay Act. All these acts we'll talk about from this point forward. So labor law was how initially issues in employment, issues in working conditions, issues in pay, and that type of thing. That was initially how the government thought, okay, here's the best practice we can do. Let's let management and labor hammer these decisions out. Well, not everywhere is unionized. Not every state treats unions the same. An at-will state will not have as much unionized workforce as a non-at-will state. At-will state being one where you can quit a job or without a real cause, or you can be fired without as long as they show enough, they can fire you without there being any type of issue. Well, we move forward 30 years And we're at the Civil Rights Act, where we began to look at prohibits employment discrimination on the basis of race, color, gender, religion, or national origin. All right. So we've come 30 years, and now we have uh, a way for the government to intervene in labor relations. So just because you're not a a company that has a unionized workforce, now you have to still abide by certain rules that may not have been fully in place prior to this. We had rules that dictated how long children could work. We had rules that dictated the ages, that were developed because of child labor issues in the 20s and 30s. So it was time to fix that. But really and truly, things like Equal Pay Act, they came about later on when different groups started having a voice in what was going on. So let's look at the Equal Pay Act. It prohibits an employer from discriminating between employees on the basis of gender by paying unequal wages for the same work. It's pretty easy to distinguish what the same work is, right? If you're both putting bolts in widgets side by side, you should both make the same amount of pay, unless there are seniority issues involved. And there are exceptions when it comes to things like seniority and stuff. But if it is two employees started at the same time doing the same job, or the other employee hasn't had any raises or anything, that position is paid the same for 30 years and it's never changed, then they would be required under law to receive the same pay. That's the Equal Pay Act. The Civil Rights Act of 1964 then prohibits that employment on the, for those discriminating basis. Now that has been added to over time. These protected classes, as we'll start calling them as we go through this, have been added to. None of those have been taken away. All those originals still fit. There's just been other classes added based upon other acts that have been brought into play with it. We have the Pregnancy Discrimination Act that extends the Civil Rights Act to pregnant women. Then you get into a commission that was formed to put some backing and teeth behind this, some enforcement power behind these acts, and that is the EEOC. The EEOC, or the Equal Employment Opportunity Commission. It can file legal actions in its own name or intervene in actions filed by third parties. It attempts to resolve alleged allegations and violations through informal means to bring in a suit. They investigate all charges of discrimination, and they issue the guidelines and regulations for concerning an enforcement policy. We'll talk about, that there are certain things that you need to have in policy to make sure that you're meeting the standards of things like the Civil Rights Act and Equal Pay Act and those type of things. And the EEOC will come in and look at policy, especially if there is been an allegation of some type of violation. They want to see your policy. They want to know what's going on. Their investigation is not just going to be what was written on paper by the two different parties to the allegation, the one being that the allegation is against and the one that's placed the allegation. They want to know, was there a policy in place to prevent this? Was this policy followed? Was this a isolated incident that could have been a mistake in some way? They want to know what's going on. Proving discrimination is going to be something that they look at, and they have a set criteria for to decide what's going to go on, to decide if there was some type of disparate treatment, and they will look at how the conduct previous had been. Was there any past discrimination that went on that builds upon it? And they want to know what is happening. Adopting some type of neutral rules that have a disparate impact can be an issue too. So sometimes the way things are set up will impact things just as much as anything else. So charges are filed with EEOC. And this is a chart that talks about those charges that were filed. And if we look at this, we'll see 2008, 2009, all the way through 2015. So it's 10 years old, and it still gives us a good idea of what was going on for this 8-year period here. So 2008, 2009, we began to have a economic crisis, banks failing, the mortgage industry collapsing was going on in 08 and 09. And as that was happening and as there was some recovery from it, you'll notice that cases of retaliation, and this could be retaliating against someone who has filed a claim, who has made a statement about what was going on, they began to increase. So in 2008, 2009, we had 32,000 complaints for retaliation. It jumped around 700 the next year, but it went from a 700 jump to almost a 3,000 jump and 4,000 report jump by 2011. As they were coming out of the crisis and as things were starting to be seen. So the crisis was the 08, 09. 10 and 11 was when, we were looking at, okay, what needs to be fixed here? What is going on? And this is when people began to say, well, this was happening, that was happening. Allegations of different practices were happening. And so there was an increase. We also saw an increase in allegations of race, not quite as big as the retaliation for, or the allegations for retaliation against employees, but there was a spike in that. Notice the rest of them do not change a whole lot, but those two go up a little bit, but especially retaliation. You had an increase in that. And then we see that start coming down, with 2014 being a low year, really and truly 12 after 2011, where there was that real good spike. 2012, they began coming down. And this is when the labor market began to go back how it should. The economy started recovering to a certain extent, and things became better. Better economy, better labor relations and employment relations. There's a correlation between, if you look at it in this sense. If we were to see the numbers for 22, 23, 24, there would likely be. So when those numbers are fully put out and you can see a range, you might see a spike in those years based upon this. Now, based upon just this sample may not be, a complete way to depict what we're going to see with the 23, 24 numbers, but it is a good indication that the worse the economy, the more issues that happen within employment relations and labor relations. So Civil Rights Act of 1964, we talked about what it bars and who it says that you cannot discriminate against, right? So there's still some defenses to that. One of those, I mentioned it earlier, is a seniority or merit system. So when it comes to pay or when it comes to promotions, the protections that are given, if there is a bona fide, in other words, a true working system that doesn't have, any loopholes in it that will allow someone to be promoted when they shouldn't be, or given a raise when maybe someone else should have had it. A bona fide seniority or merit system is a defense to that. If you can show that we have used the same way of promoting, the same way of pay, whatever, based upon seniority or the merit of the employees, then you can use that as a defense. If there is a professionally developed ability test in law enforcement for promotion, there are what are called bar exams, kind of like, not exactly like what lawyers go through, but they take sergeant's bars or lieutenant's bars. They take exams for that. Their study across the board, and a lot of jurisdictions will use a kind of a clearinghouse that handles these type of things. So it's not something done in house. They all would take the test, and then based upon a set of numbers, they would do that. Uh, Departments will change their promotional policies based upon issues that have arose, that came up prior to those policies being in place. Uh, Working with Department of Corrections for quite a few years, there were times where there had to be changes made in promotional policy that fit into allegations that have been made, and corrections would be put in place so that those allegations shouldn't be made again, and that type of issue shouldn't arise. All right, so professionally developed ability test that was built into the interview process. Everyone got the same questions. Everyone uh, was rated on the same uh, in the same way. Number of years, your last three evaluations, and those type of things would be how you were looked at. So your last three annual evaluations were given a point value. Your years of experience were given a point value. Your answers to questions that really and truly had fairly, cut and dried answers were given a point value. And then there were a couple of questions that put you in a scenario where the only outcome uh, could be an answer based fully in policy. Those would be given a different way of point value depending on how those are answered. That was a way they looked at it, and it showed the ability of those being interviewed for promotion. A compensation system based on performance results and a bona fide occupational qualification doesn't apply to discrimination based on race, but a compensation system on performance results. This has to be for this to be a defense, there has to be a set standard, and everyone is graded on that standard by their position, by all other factors. So all the factors being the same, then we have a compensation system that's based solely upon their performance in that job. If they have to do, X to be considered fully productive, and they only get to, T or whatever, then they're not showing their full productivity, and they would not be considered maybe for those compensation increases or whatever. So it would have to be a set goal for everyone who is in that position, and they have to reach that performance goal to get whatever the compensation increase or whatever it's going to be. But it would have to be a set goal that is the same for everyone. They can attain something that is not subjective but objective. The difference being subjective is you get to put your opinion in. Objective is based on cut and dried results. This is what it is. It has to be this going forward. A bona fide occupational qualification, which doesn't apply to anything on race. And then a fifth defense is a business necessity, is available in disparate impact cases. A business necessity could be that you're doing business somewhere where it would be inappropriate for someone of a different gender to be in that establishment, whatever those cases would be. Or there are times when a business necessity is indicated by, someone having to have a certain license, and there are certain impairments that would prevent that license, someone needing a CDL license, and there are some impairments and some conditions that would prevent them from getting that. A business necessity is that CDL license. So at that point, you could discriminate against someone who could not pass that test, someone whose health is not to that point, or whatever it could be. Remedies to it, if someone has violated that, can include injunctions, affirmative action, getting them back on par where they need to be, reinstatement of someone who may have been disciplined or removed from a position. They can have to pay back pay and compensation, and then punitive damages. So they could go through that and have to pay out a lot of money. An injunction against them can come with fines and things on those lines. Having to give someone back pay and compensatory and punitive damages could be very, very expensive for a company if they are found to be in violation of the Civil Rights Act of 64. So it's important to know what that is and know what your rules there are and how you're working within that system to make sure that you are not violating, because it can become very expensive. Sexual harassment is a legal form of sexual discrimination. That it includes sexual advances, requests for favors, verbal or physical conduct of a sexual nature. It can be something as simple as telling a joke of a sexual nature in the presence of someone who does not want to hear that joke, whether they are of the same or an opposite gender. Telling that joke in their presence when they have asked you to stop can be sexual harassment to a certain extent, which means that you have, done something that they're not comfortable with, some type of verbal conduct of sexual nature that they're not comfortable with, and they've asked you to stop. And so those claims should be filed. The thing with sexual harassment, when we think about it, we concentrate on someone who is female gender being sexually harassed by someone who is a male. That old stereotype doesn't fit, because we have female on female, female on male, male on male sexual harassment just as common, but maybe not as quite reported as much because of those stereotypes that still exist, especially for someone who may think that, well, I'm going to look weak if I go forward and report this harassment, when they need to, because they may have been denied a position because of not acquiescing to the sexual advances and those type of things. So that is where the stereotypes really hinder some of the reporting that needs to be done under the Civil Rights Act. Comparable worth setting is equal pay for jobs that are of equal value to the employer. So a job that can be shown by whatever means to be of equal value should be equal pay for those that are in it. A reverse discrimination is an affirmative action that directs an employer to consider an individual's race or gender when hiring or promoted for the purpose of remedying underrepresentation of that race or gender in traditionally segregated jobs. There was it was either toward the end of last year, beginning of this year, in the news, there were quite a few cases where some reverse discrimination lawsuits had came about. And, like anything else when it comes to law, and especially something that is, the federal government handles, the U.S. government handles the cases, especially with something like this, where it is a department within the government that looks at these. Depending upon administrations will depend upon what kind of suits are filed. Because unfortunately, because of our system and how our system runs and how much disparagement there is between political beliefs, you're not probably in your best interest to file reverse discrimination if a party who looks down on those is in place. The same way, filing discrimination cases, sexual harassment cases, filing those type of things when the political climate may not be in your favor, you will sometimes have to be something that's taken into consideration. And unfortunately, that is a result of the last 10 years or so of political climate, really and truly more than that. Probably since the, you know, somewhere around the mid 90s, we've began to form that gulf that wasn't quite always there, but now it is to the point to where, you know, people make decisions based upon who's in power. Is this going to be favorable for me or not? Do I wait until, or how do I do that? If someone is discriminated against, especially as an employee, if you've been discriminated against in any way that this talks about and this covers, you need to report it because there needs to be some record out there so that even if you do not get satisfaction now from the report, you do not get any remedy from it, there's a report of it. You get a copy of the reports. You make sure that you have everything that are by law allowed to have, so that you can keep a record, and so that as it continues, because it will, if it's not remedied when you report it, it will continue, and if it continues, you have paperwork showing. So do not make your decisions off of whether you report some type of discrimination, no matter what type it is, based upon who's in power, what they're doing. Make your decision based upon your rights as an employee to be treated fairly by your employer. Executive orders have been put out, and an executive order was released to make sure that anyone who held a federal contract, that they were adhering to the federal discrimination laws that were in place. Age Discrimination Employment Act came about 3 years after the Civil Rights Act, which put a age number on where discrimination begins, which is 40. Anyone over 40, if they feel they have not been hired because of their age, or they've been fired because of their age, or their compensation is different because of their age, they can then file a claim with the EEOC that they have been discriminated against based upon their age. A lot of these are in hiring practices, but then again, there are some groups that can discriminate based on age because it's a need or a condition or whatever it may be of employment they're allowed to have. Disability law, there are several acts on it. Of course, the ADA is the most widely known, Americans with Disabilities Act, and provides assistance to the disabled in obtaining rehabilitation training, access to public facilities, and employment. It's the same. The act that protects employees with disabilities is the same one that dictates that sidewalks have a ramp instead of a step, that trip and fall hazards have to be marked if there's not a place to put a ramp in. If there's only the option of steps, that those are marked fully so that they're seen in a bright color. The ADA also states that in a public place, the sinks have to be at a certain height. There has to be the availability of someone in a wheelchair to be able to roll up to a sink and wash their hands or use any other facilities in a restroom. That counters, there be at least one register or counter that they can access from the wheelchair, those type of things. That's all part of the ADA. And that's where most people think about the ADA. The ADA works for employees too when they're being discriminated against because of their disability, whether it's not being hired because of it or being treated different. And these are all based upon a reasonable accommodation. So someone who is filing based upon the disabilities, the ADA, and filing a lawsuit on that being discriminated against because of a disability, it doesn't mean that the employer has to completely change a company to hire someone, but there needs to be reasonable accommodation is what it's called. So a reasonable accommodation is maybe lowering a work surface or allowing someone to use a text to or a talk to text that may have an issue typing, those type of things. So accommodations that will allow them to do a job. Can the job be done with a reasonable accommodation? If it cannot, then there is a remedy to the ADA as far as the hiring practice goes. But if that job can reasonably be done with an accommodation for disability X, Y, and Z, then the employer cannot actively prohibit someone in that with those disabilities from applying or actively discriminate against them if there is the possibility that with a reasonable accommodation they can do the job. Genetic information discrimination. We'll go back to it real quick. If we look at this slide again, do it over here. Went it on one screen but not the other. Look at this slide again. Genetic information was not something in place prior to 2010. And you'll notice there have been some cases filed, a spike in those. They kind of stayed even in 13 to 14, and then came back down in 2015. But that is a fairly new discrimination that forbids discrimination on the basis of genetic information with respect to any aspect of employment, including hiring, firing, pay, jobs, layoffs, promotions, fringe benefits, any condition of employment, those type of things. Okay, so genetic information. The book describes that in a little bit more detail. Get to it real quick. It was an act that came out in 2008, and basically it explicitly states that disparate impact on the basis of genetic information does not establish a cause of action. GINA is what it is, the Genetic Information Non-Discrimination Act. It's illegal to harass a person because of his or her genetic information, retaliate against an applicant or employee because of the person complained about discrimination. They filed a charge of genetic discrimination. The basic rules that apply and the injunctions, things that would apply to someone who is filing a claim under the Civil Rights Act or ADA or any of those applies to someone under the Genetic Information Discrimination Act, based upon knowing their genetic information. Federal employment discrimination laws. So this puts them into a nice little neat chart to look over and to see. That is the Equal Pay Act. Title 7 of the Civil Rights Act is the one that handles employment. The ADA and the Age Discrimination Employment Act. All right, so they're based upon a protected characteristic. So a protected class in this is someone who's disabled, someone of their gender is protected. It's protected class, race, color, gender, religion, national origin. There are a lot of other pieces that go into this, disability, age with that, and that is how those are boxed up and boxed together. Employee protections. So in that employee protection, employee termination at will under common law, a contract of employment for other than a definite term is terminable at will by either party. All right, so when you hire in a state like Florida is an at will state, at any point you can leave a job if you do not have a contract that states you will work from 1/1 of 2025 till 12/31 of 2025. If you have a contract that states you will work in that specific job doing that specific practice, whatever it is for that time frame, then you trying to leave that job could constitute a breach of contract. An employer trying to remove you from that job could constitute a breach of contract. But if you do not have such a contract in place and it's just a normal contract of you're going to come here and work and we're going to pay you, then in Florida and at will state, which are many other states are at will states, you can leave that job without there being any type of issue with a contract or breach or anything like that. There are statutory limitations on it. The federal government, some states put those in judicial limitations based upon contract law, tort law, and public policy when it comes to at will. OSHA, not the organization, but the act that that organization came out of. The administrative agency of OSHA came out of the Occupational Safety and Health Act. That was enacted to assure a safe and healthful work environment. We kind of know how that, OSHA works. Most people have dealt with them in some way, had a job that may have involved them. If you ever worked in construction or anything where tools are used or any type of equipment, they probably came around to check and make sure everything was good. Some states will prohibit a test for prescribed certain scientific or procedural safeguards when it comes to drug and alcohol testing. They'll either prohibit the test completely or say there has to be steps that are followed above and beyond what is normally there. Federal statute prohibits private employers from requiring employees or prospective employees from taking polygraphs or lie detector tests. At one time, that was a common practice when hiring were lie detector tests. I can remember my dad talking about it when I was, a lot younger. So over 40 years ago, well over 40 years ago, they had these in place. Yeah, workers' comp. It's compensation award to employee who's injured. That's one of the things that comes about when you're injured on the job. It's the insurance policy basically that employers carry. They carry workers' compensation insurance is basically what it is, and that is money that is paid to cover medical expenses, lost wages to a certain extent for a certain period of time until maybe a disability type policy would have to kick in by the employer, those type of things. Social Security is something that we pay in when you receive your paycheck. If you look on a pay slip or a pay stub, most of those are electronic now. If you look on it, you'll see FICA. That is your Social Security you're paying in hopes that one day you'll be able to draw on that Social Security when you get ready to retire, or if you unfortunately become disabled, to be able to use that money. You pay into it, your employer pays into it to a certain extent, and that money is set aside and goes toward your future. Unemployment insurance, it provides compensation to employers who have lost their jobs or cannot find other employment. Layoffs, things along those lines. Unemployment comes into play there. You do have to apply for that. It's not an automatic. It doesn't automatically kick in, but you go through a process of applying for unemployment. Part of how we handle labor statistics in the U.S. is a number of people who have filed unemployment claims. And if you're filing an unemployment claim, you go into that mix and you become part of, the job openings report that comes out ever so often. So it looks at that. Then the Fair Labor Standards Act regulates employment of child labor outside of agriculture. Then agriculture, there are definite differences to how child labor policies are worked at and looked at. The Worker Adjustment and Retraining Notification Act, the statute that requires an employer to provide 60 days advance notice of a plant closing or mass layoff. So if there's going to be a large layoff, there has to be a notice. We've seen more and more where some companies have not been doing this when they filed bankruptcy. There may not have been a full 60 days, but there should be in that. And then FMLA. Most people have heard of this. They may not have heard Family Medical and Leave Act, but most have heard of FMLA. It requires employers to grant employees a leave for serious health conditions or certain other events. There's a list of things that FMLA apply to. In most cases, it's 12 weeks that they are required to allow you to be off and bring you back into that position without you losing your position in any way. It doesn't mean that you have to be paid. FMLA can be unpaid if you do not have the leave build up to be able to use to cover the time you're taking off. So FMLA doesn't require payment. It just requires them to allow you to take off for certain conditions or serious health issues that may arise. And then you can, come back to your position that they had to hold open for you during that time. And that does it for employment law. There's a lot that goes into it. There's a lot more that would go into it. There's actually a whole class at Santa Fe on employment law that's required in one of the AA or AS degrees. So there's a lot that goes into it. You can spend a whole class talking about just the little parts we talked about. There's a few more things that go into it, a few more rules that may apply as far as that goes. So yeah, it's a big part of what we do as, if you're a business owner, what you do there, if you're in management, what you do, it all builds in how that is done, how that is set up. But that does it for this time. So if you have any questions, please reach out. And once again, like at the end of every video, stay safe and study hard.